I'm glad that we had a discussion just a little bit earlier about Indiana and about what is or isn't radical, because I'd like to talk about that a little bit while we have both Secretary Ritchie and Representative Kiffmeyer here. And I think something that's been lost in this discussion is that we are talking about a constitutional amendment. This is a big deal. Representative Erdahl, Representative Beard, others who have been here a long time, we don't normally, that is until recently, do these all the time. Now apparently we do. So we're taking strong policy preferences, which don't need to be in the Constitution, and putting them in the Constitution. You know, I did some research, and if you look at NCSL, it's all there on their website. There are 31 states with some sort of voter ID requirement. 8 have sort of the hard requirement, as Mitt Romney might say, the severely conservative requirement, and that's what this would be. Then another 7 have a photo ID requirement, but it doesn't have to be government issued. It could be your, fitness club card, or it could be some other photo ID card. And then there are another 16 states that have some ID requirement, but not necessarily a photo. It can be a utility bill or something else. So 31 states. Only one state in the country, only one, has done this by constitutional amendment, and that's Mississippi. So now our one peer, if we pass this, will be the state of Mississippi. Even conservative states with conservative legislators, thoughtful, serious people like we have here, who are trying to do something that they feel strongly about, even they showed the self-discipline and the self-restraint not to put a simple policy preference in the Constitution. That's not what we're seeing here. We are seeing really the opposite of conservatism, the opposite of self-discipline, of self-restraint, and of not doing what feels good. What we are seeing here is constitutionalizing policy differences. And by doing that, we're basically writing in permanent ink. We are putting very serious subject matters beyond the reach of future legislatures from all practical purposes. We are imposing our will on future generations in a way that a statute doesn't. We've heard today a lot of technical issues with a very technical subject matter. We've heard a lot of definitions that we don't know about. We've heard that this is not a simple thing. I know how this issue polls, and I understand why it polls that way. People aren't dumb or wrong for telling a pollster that they think this might be a good idea on its surface. But there's a lot more to it than that. I think we would all agree. And by putting these things and these definitions in the Constitution, never to be changed again unless by another constitutional amendment, I think we're really, really playing with fire here. And I think we have to think about that.